Good morning, everyone. Good morning to everyone here in Assembly Judiciary, as well as those in Las Vegas, and anyone watching online from the Legislative YouTube channel or from Nellis. And with that, Committee Secretary, please take the roll.
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Here. Marzola.
Present.
Moore. Here. Nadeem. Present. Orient Liquor. Roth. Here. Europe.
Here.
Chair Miller.
Yes, I'm here. Senator Nguyen? Yes. One moment. Be at ease, please, for a moment. Good morning again. Welcome to another deadline week. As you can see, things get a little, they just need a little more attention on deadline week. So with that, a few more reminders. Please make sure you turn your electronic devices down. I will provide the phone number and today's meeting ID so that you, those of you who will be participating over the phone for testimony or public comment already have it ready to go. The phone number is 888-475-4499, and the meeting ID today is 874-941-43712. Also, just a few reminders, you may see members coming and going as they may be presenting in their own bills in other committees. I'm sure we marked Assembly Member Ornlicker present. Okay, thank you. Today we have two bills and a work session. So we will begin with the work session and then go into our bill hearings. Just a reminder to anyone presenting on a bill, please make sure that you keep your comments to your remarks to 15 minutes, and those testifying or making public comment today, please make sure you keep your comments to 2 minutes each. We ask that everyone state their name first for the record and spell it the first time you speak so that we have it correct. And with that, we will go ahead and begin with our work session. So turning it over to our policy analyst for Senate Bill 20.
Thank you, Chair. For the record, Cesar Magrejo, Community Policy Analyst, and as a nonpartisan LCB staff, I'd just like to remind the committee that I can neither support nor oppose any of the measures that come before this committee. The first bill is Senate Bill 20, which revises provisions relating to criminal procedures and sponsored by the Senate Committee on Judiciary on behalf of the Nevada Supreme Court. There is an amendment that was submitted by Jason Frierson of Cornerstone Government Affairs, representing the 8th Judicial District Court, which is to require jury commissioners to use Department of Health and Human Services information unless federal law prohibits it when compiling jury selection lists, and to authorize DHHS to provide a list of public assistance recipients for jury selection only when not barred by federal law or regulation. And Madam Chair, that's all the amendments.
Thank you. Members, questions? Not seeing any questions, I'll entertain a motion to amend and do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assembly Member Gonzalez. Any additional comments about the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will assign that floor statement to Assembly Member Urick. Senate Bill 347, please.
Thank you, Chair. For the record, Cesar Magrejo, Community Policy Analyst. Next bill is Senate Bill 347, which revises provisions relating to mental health crisis holds, sponsored by Senators Scheibel and Canizaro et al. And there is an amendment that was submitted by Paloma Guerrero, which is to clarify that the officer may confiscate a firearm only if it is found on the person or in their immediate vicinity during a mental health crisis hold, rather than any firearms merely under the person's custody or control. And Madam Chair, that's all the amendments.
Members, any questions? Not seeing any, I will entertain a motion to amend and do pass. I have a motion from Vice Chair Marzola. Do I have a second?
Second.
I have a second. Was that Assembly Member Moore?
Yes.
Okay, I will take the second from Member Moore. Any additional questions or comments? Assembly Member Hanson?
Thank you, Chair. Boy, really getting there with this one and like the intent. Still some remaining issues, so at this point going to be a no, but hoping I can get that clarity on the actual returning process when we get to floor. Thank you.
Thank you. Anyone else? Okay. All those in favor, please say aye. Aye. Anyone opposed? Nay. Nay. Okay, so I see the hands of Assembly Member Urick, Hanson, Cole, Gray, and Hardy. All right, thank you, members. This passes, and I will assign this floor statement to Assembly Member Moore. Thank you. Thank you so much, everyone. We will now move into our bill hearings, and we are going to begin with, we are taking the bills out of order, so we will begin with Senate Bill 404, which revises provisions relating to personal financial administration. So, Senator, your hearing is open, and I understand you have some co-presenters, and whenever you're ready, please proceed. Everyone, just make sure you please introduce yourselves and spell your name.
Thank you so much, Chair Miller, members of the Assembly Judiciary Committee. My name is Melanie Scheibel. I am the State Senator for District 9 in Southwest Las Vegas. I am happy to be here today presenting SB 404. I am joined by Kenny Lee as well as Michelle Rafferty, both esteemed attorneys here in the state of Nevada, to help me present SB 404. And I'll just give you I'll try to be very brief with my overview of the purpose of SB 404. It does two main things. The first thing that it does is it revises some statutes related to probate administration to ensure fairness for Nevadans and to prevent bad actors from utilizing loopholes within the probate statute to enrich themselves and leave heirs out of the process. The second thing that SB 404 does is provide updates to a variety of statutes within the probate and trust section of the NRS, as has been recommended by the probate and trust section of the Nevada Bar. And they go through a very extensive process to vet these recommendations before bringing them to a legislative member and before suggesting them to the legislature. You also do have an amendment on, I think it's on Nellis. We brought a couple copies with us. It's not terribly long. We're removing two sections, or we're suggesting to remove two sections of the bill that maybe require a little bit more conversation to get the wording right. And then it fixes a clerical error that these eagle-eyed lawyers found in a subsection of a subsection that referred to the wrong other subsection. And so if you thought people didn't read bills, this is your proof that they actually do. And with that, I will turn it over to the experts to talk a little bit more about the provisions of SB 404, starting with Mr. Lee.
Thank you, Senator Scheibel. Kenny Lee, Kennylee. Good morning, Chair and Assembly. I'm going to provide a little information on background of independent administration, which is being changed here. Probate is a unique area of the law, and so some of the procedures and processes are a little different than many other areas of the law. As Senator Scheibel indicated, there's been concern of bad actors in the past using certain tools that were intended to help the probate process when families get along and there's no problems on the horizon. But they've been using these to enrich themselves in inappropriate circumstances. The independent administration, I'll explain how that works in Nevada. In Nevada probate procedure. Independent administration is intended to expedite the probate process and to reduce administrative costs. It's important to understand who it is intended for, as well as what cases it's not intended for. Primarily, it's targeted for situations where the family or the heirs or the beneficiaries, those interested parties, those who are going to inherit, all get along, have a good relationship, open communication, and there's no need to overcomplicate the process, causing unnecessary expense or delays. However, if there are disputes, if there are problems, if there are issues that need to be litigated or worked out, independent administration is not for those types of cases. Additionally, it's not a proper tool to be used when there are unknown heirs, which happens not infrequently as individuals with limited family move to Las Vegas as a retirement community, end up retiring here, passing away, and there are no close family members involved. And so we do get that pretty regularly. Independent administration is not for those types of cases. The primary, or at least one of the primary benefits to independent administration is the ability to sell real property expeditiously. To understand how that happens, we need to know the normal process in probate. In order to sell real property, we petition the court, providing all the details relevant to the sale, asking the court to confirm the sale and allow the transaction to happen. At the hearing, the court will consider the details of the sale and will also ask in the courtroom if there are any interested parties, any other parties who are willing to offer more than the current contract price. At that point, the courtroom essentially becomes a mini auction house for the sale of such property. Sometimes there are parties who are willing to bid more. They find that there's maybe some value here, and sometimes there are not any parties interested in bidding more. But this process helps ensure that the property is being sold for the right price, that it's a fair market price, and that the estate is receiving the proper value that it should. Independent administration can skip this entire court process. It allows the parties to skip the expense and the waiting period and the time involved in such hearing. Sometimes the heirs feel that the price is fair and they're not looking to squeeze every single penny out of a possible sale just to incur additional time and expense. They just want to move forward with the process without additional cost and time delay. Or sometimes the interested parties, the heirs or beneficiaries, have a specific buyer that they want to buy the property because of some prior relationship, some family relationship, some connection to the decedent, some other reason other than a financial gain that they want this individual to have the property. If all the parties are involved that could be affected, such would be a proper action. However, in order to proceed with such a sale, the personal representative the individual in charge of handling the probate, must give all the heirs and beneficiaries notice regarding the details of the sale. Essentially, the information that would be provided to the court in a petition must be provided to all the heirs and the beneficiaries. This is done through what we call a notice of proposed action. If a notice of proposed action is not provided, then there is no authority to take the proposed action, in this case, a sale. Those details must be provided to all interested parties. Because the notice of proposed action is just that, it's a proposed action, the personal representative does not have the ability to force such action on the heirs. If the heirs look at the details and they do not agree with the terms of the sale, they have the right to object and inform the personal representative that they think the proposed action is inappropriate, perhaps the price too low. And in a situation like that, the parties must now go to the court and ask the court for confirmation of the sale. So it's not a tool used to force it on parties who are not in agreement, but it is a tool in the right circumstances. As Senator Scheibel indicated, there's concern of parties who are not related, who may be considered predatory, to line their own pockets in using this independent administration to sell properties at less than fair market value. And this is how independent administration needs to be revised to make sure that it's being used for the right parties in the right situations, but taken away from the parties who would abuse it.
Thank you so much.
Senator Scheibel, I will turn it over to you.
So Senator, will you be taking us through the bill?
I'm actually going to turn it over to Ms. Rafferty, who I think is prepared to either walk you through all of the sections or give you the highlights,
Highlighted
since
version.
it is 56 pages or so.
Yes, and we again ask that presentations in its totality be kept to 15 minutes. So yes, please give us the highlights.
Thank you. Michelle Rafferty, for spelling, it's Michelle, Michaelle, Rafferty, Rafferty. Thank you for having me here today. I serve as co-chair of the Legislative Committee for the Probate and Trust section of the Nevada State Bar. Also on the call today is my co-chair, Jeff Lushak. The bill that you have before you walks through, I will walk you through the sections very quickly. Some of them you may have some further questions on. I'm happy to address. With regard to Section 1, Section 1 is simply some cleanup. Sometimes in these sections we end up with a word that is missing in a statute from a prior provision, and so Section 1 is really just cleanup of those provisions. Section 1.3, just to note, we're removing the telephone number from being required to be published in court proceedings. These are privacy type related issues. Moving on to Section 2. Section 2 is again dealing with some cleanup language in order to make sure that we have proper definitional provisions for Section 139.040. And Section 3 walks into the provisions that Mr. Lee just spoke of, 143.360, which is the Independent Administration Act. Walking through that Independent Administration Act moves us on to Section 4, which is NRS 144.010. Again, you will see just a very few minor changes. This is because there are some places in the bill where executors are differentiated from an administrator, and so we're trying to clean that up and make sure both executors and administrators are consistently addressed throughout the code. In addition, 145, which is Section 5, increases the amounts for modest estates. Nevada's a little bit behind on what the value of an estate is in the process that we go through. We want to make sure that our estates aren't required to go through onerous tasks when they're lower dollar amounts. So those amounts have been increased so that a summary administration will now be at a $500,000 estate instead of the previous $300,000. This takes us through Sections 7 and 8 and 9. Again, just slightly increasing each of those sections so that families with more modest estates can move through the probate process a little more quickly. Section 10, again, just deals with the issue of a small estate and moving that from a small estate affidavit from $100,000 up to $150,000. Section 11, under 155.020, we are cleaning this up as well, dealing with administrators and executors, making sure that both probates of wills and of intestate succession proceedings are giving proper notice to all parties in the same manner so that we're not leaving any notice, individuals entitled to notice out from from receiving those notices. Moving forward, probably the most substantive change would be in Section 12. Section 12 is for the first time we do not have a statute of limitations in our statutes dealing with a breach of fiduciary duty. So surprisingly, we did not have that, and this is to clarify that statute of limitations will be set forth. This does not affect the statutes of limitation we have on fraud or willful conduct. Those are already in the statute, but this addresses the smaller, the lower standard of negligence and making sure that we do have a statutory limitation in place. Senator Scheibel mentioned we are requesting the amendment to remove sections 13 and 14, so I will not go through those. Primarily, those do need a little bit more work and vetting with other sections of both the state bar as well as with the legislature. Section 15, 16, and 15 and 16 will likely by the LCB be removed as well, simply because they relate to 13 and 14, so I'm anticipating that will occur. And then moving to Section 17 again, this is just a cleanup of the prior language that I mentioned, again, addressing the decedent and who that is and the powers that they will hold. When I move into 18, this is probably one of our more newer provisions. This is to clean up the definition of distributions to a trust when they're vested. We end up with a lot of cases where an old trust agreement has language perhaps that says a distribution will be made to in further trust to a trust, and then the trust that it's supposed to go to says that it'll terminate and distribute when that beneficiary turns 35, for example. Well, a lot of times that beneficiary is already 35. And so to have to move the property from the current estate into a trust that's merely going to be terminated, this allows us to skip that step. We can just move forward and, as long as the parties agree, distribute directly to that beneficiary who's entitled to the distribution without having to form the interim trust in order to accomplish that. Section 20, dealing with 163.557. This provision deals with a new section, an amendment to an existing section dealing with tax reimbursement of grantor trusts. And again, this is to deal with a provision. It was based on an IRS ruling of recent times indicating that certain restrictions apply to the amendment or modification of a trust in order to add the ability to reimburse the person who paid the taxes for the trust. Generally speaking, that's going to be the grantor, the person who set that trust up. This allows the trustee to reimburse that grantor of what we call a grantor trust under the Internal Revenue Code proceedings, and it makes Nevada current with current trust law around the state, keeping us very much on the cutting edge of being a state where people like to bring and administer their trusts. I do note that we have a typographical provision that is requested to be amended in Section 7.2b of that section, just changing the subsection number from 1 to Section 2 in order to correct that provision. Section 21 deals with the ability for beneficiaries and interested persons to receive copies of the estate planning documents and defines what documents will be required to be provided to those individuals should the trustee seek to provide a copy and trigger the no contest provisions. In Nevada, a person who receives the documentations has 120 days to contest an estate plan, and so this just defines exactly what is to be provided to the individuals in order to trigger that 120-day provision. Section 22 This just deals with the administration provisions of a trust. We do not have a definition in Nevada for what it means to administer a trust in the state of Nevada, and so this is to make sure we do have a definition of that. We have a lot of people who bring their trusts to Nevada for further administration, or they may have trusts that adopted Nevada law, but maybe they're administering them in different states. And so this provides clarity as to when Nevada and a Nevada court will consider a trust to have been and be administered in our jurisdiction. Section 20,
And I'm going to ask if you can, because we're going on,
15 minutes.
oh, no, we're well past 15 minutes.
Okay.
So I'm going to ask that you, kind of just quickly highlight again, so that we can get to questions.
Great, wonderful.
Thank you.
As far as other substantive provisions, there's updates to the accounting statutes to make sure that when trustees give an accounting, they are, the 90 days will pass, the trustee is released from any further responsibility for that. And I believe that really covers the bulk of the materials. Section 24 deals with provisions that are related to Section 13 and 14 and updates to those, so I believe those likely will fall out, and I don't need to go through those as well. Happy to take your questions, if any.
Thank you so much. I will give the members a few moments to jump in if they do have questions. I have a question, and if it could be explained. So I'm on page 3, section 1.2. And so, again, I appreciate this bill coming forward because we know that when people pass and if the money is, and property isn't all very well designated, it does become, it's a major issue for families and such, and especially here in Nevada, where we often have household of one. You may not have any relatives or anything here. But my question goes along, and if you could maybe help explain the order or why this was determined in the order of who would be in charge, basically appointed as an administrator. I see that new language was added to add the grandchildren, other issue, which thank you to legal who just explained, because I was like, wow, other, before a parent or a sibling, other issue. So I did get the legal definition of that. So would you like to explain what the legal definition of other issue is? If that, we'll have our legal explain, yeah.
Sure, Carly O'Krent for the record. So it's my understanding that other issue in this context means lineal descendants other than those that are already mentioned. So it could include great-grandchildren, things of that nature.
So, again, an interesting, because I guess I'm really just, my two questions on the order here are, one, because then I was going through trying to figure out where it talks about if a minor is an heir, but it doesn't talk about an administrator being a minor. And so, again, often the children, the grandchildren can be minors. And like I said, I could see where it talked about an heir being a minor, but not an administrator. And then I guess I'm just curious about the order, why this was put in such a specific order.
Melanie Scheibel for the record. I can speak at least, I think, to most of that. It was already, identified in a pretty specific order in statute when we opened it up. One of the big things that we did was change the brother or sister to a sibling, just to have a little bit more expansive language. And I think I want to point out, and Mr. Lee can correct me if I'm wrong, this order of priority is if the court has to make an appointment without an agreement from the other parties. And so if you do have a situation where there are living children and siblings and grandchildren, they're not bound by this order of priority. If, different family structures are different, right? And so it's really difficult to put into, I think this kind of goes to your point, it's very difficult to put into statute who should be in charge because different families are different. And so this is supposed to provide a guide for judges when there is no input from the family, but certainly if you had a parent and a sibling both there and they agreed that they want the sibling to handle the estate, there's nothing stopping a judge from allowing that to happen.
Great, thank you. We actually just went through this with my family back in Michigan, and it was as simple as my aunt never had children, but she's got, 8 first nieces and nephews alive, and so we all just signed a form, yes, and making the oldest cousin, in charge. But the next question is, so I hope it is as simple here as well, where everyone just signs off and says, yes, we all agree this person can be in charge. So would it be that simple for families here?
Michelle Rafferty for the record. So first, let me follow up that this priority tracks the distribution of the estate and how individuals would be entitled to distribution. That's really why the priority is set out the way it is. It's the person who is the most interested, likely to receive under intestate succession, would be the person that would be appointed. So that's typically just tracking the earlier statutes in our code for intestate succession. And then that would be the most likely person to be interested in having a say in the administration process. As far as what would happen if they did not agree, if there was a disagreement in the order of who would be appointed, certainly and everybody's entitled to notice of those proceedings and would have the ability to come forward and to assert if there's a difficult situation, perhaps somebody has some reason why they do not want the individual who is seeking the petition to be appointed. Our court system would allow for them to have notice of that process and to state their claim, their objections for the record, and to propose an alternative to that process. So that is already well set out in our statutes for how that would progress.
And so for the second question, if someone is a minor, is it we're just bypassing them and not considering them? Because I see where it talks about an heir being a minor, but not necessarily.
Correct. In order to be an administrator, you do have to be over the age of majority. That is in a different section, code section of our provision for a qualification of an administrator. And so if they are not over the age of majority, a minor could not serve.
Okay, thank you so much. Our next question is from Assemblymember Cole.
Good morning. Thank you. Thank you, Chair. My question is in section 20, and I believe it's subsection 7. It's on page 39 to make it easier to flip through. So as I understand it, parts of this bill on the trusts will apply to all trusts created in the future and also existing trusts that were created before. And so my question is there a notification process to everybody to let them know so that they have, that time frame, 60 days for them to contest this being applicable to them? Thank you.
Michelle Rafferty for the record. So first, this provision would apply to trusts that are called grantor trusts. These are trusts in which the grantor who sets the trust up is the person under the Internal Revenue Code that will pay the tax. So that part's already in place. Some trusts have language in them already, and in accordance with our currently existing statute that allow the reimbursement to occur, and the trustee has authority to do it. This statute will make it so that even if the trust itself doesn't have that language, the trustee would have the discretion to evaluate whether to reimburse the person who paid the tax, the grantor, in this automatically. The statute provides a provision for a waiting period after the statute becomes effective for individuals to be able to come forward and modify or object to that provision. Generally, what would happen in the trust and the estate world is in the state of Nevada is that there would be a series of state bar meetings and requirements to inform counsel for those provisions, and so to make that aware, so that everybody is aware in the bar. There isn't an actual formal notification process, but that's not unusual with our statutes. Generally speaking, when we do pass trust statutes, they do affect the trust instruments moving forward, regardless of whether the trust says otherwise. Now, if the trust does contain a prohibition, the statute will not override that prohibition. So if the trust did specifically say there is no reimbursement allowed, we can't override that.
Thank you so much. Our next question is from Assemblymember Orlicker.
Thank you, Chair, and thank you for bringing this. I want to go back to Section 1.2, subsection 5, where the court is allowed to waive the order that's set out in certain circumstances. And you mentioned some reasons why they might want to change the order, like if the family agrees. I was just curious why you structured it the way it is, that it has to be in favor of lower ranking people who have equal or greater shares. So if you could, since they have, it's already set up in terms of priority of inheritance. So if you could just explain 1.25.
Michelle Rafferty for the record. So section 1.25 basically allows for the court to consider those people who are of similar class and in a similar, so you could have several children, for example, would be an example of not who don't get along and who are fighting over whether or not one of them is better to be in that position. In that example, the court then could interpose itself and exercise its discretion in order to appoint the person that the court determines is appropriate, or alternatively, somebody else other than the ones that are fighting over the right to be in that particular position. Does that fairly answer your question?
And if I could also turn it over to Mr. Lee, he worked with me on this section and might be able to offer some insight.
Well, I can first offer that calling family members lower class or lesser is not going to help in a situation like this. But yes, please.
Yes, Kenny Lee, for the record. One of the big things with this part of the revisions is to, as Ms. Rafferty indicated earlier, to track those who are going to receive distributions, inheritance at the end of the day. Unfortunately, there are times that come up where someone ends up in control that doesn't really benefit from the assets of the estate at the end. And so they have conflicting interests where there might be some animosity among the family, and they're using their position to exercise some of their feelings towards other family members. And so we want the actions taken by the personal representative, an executor, an administrator, to be for the benefit of those who are actually going to receive the net assets at the end of the day. We don't want somebody else who's not going to receive them making decisions because it doesn't track interests as well.
Okay, thank you. With that, I don't see any additional questions. So I will go ahead and open it up for testimony in support, beginning here in Carson City. Those who wish to testify in support of Senate Bill 404, please come forward. Not seeing anyone here in Carson. Is there anyone there in Las Vegas? Not seeing anyone come forward. Broadcasting, will you please open the lines?
The public lines are open and working. There are no callers at this time.
Thank you. Then I will go ahead and open it up for opposition testimony, beginning here in Carson City. Okay, not seeing anyone. Not seeing anyone in Las Vegas either. Broadcasting, please open the lines.
The public line is open and working. There are no callers at this time.
Thank you. Is there anyone here in Carson or Vegas for neutral testimony? Not seeing any. Please open the lines.
The public line is open and working. There are no callers at this time.
Thank you. Senator, would you like to make any final remarks? Okay, thank you. So with that, I will go ahead and close the hearing on Senate Bill 404. Next, I will open the Senate hearing on Senate Bill 168, which revises provisions relating to cannabis.
Good morning, Chair Miller and Vice Chair Marzola and members of the Assembly Judiciary Committee. For the record, I'm Rochelle Wynn and I represent Senate District 3, and it's my honor to be here this morning presenting Senate Bill 168. And just a shout out to the Chair for giving me a little bit of indulgence this morning to hopefully correct some of the details that have moved people out of opposition and back into neutral. So, as you know, Nevada's cannabis industry is only 10 years old, and the agency that regulates the industry is known as the Cannabis Compliance Board, is less than 5 years old. Last legislative session, I sponsored 2 bills that added more consistency and transparency to how the CCB regulates the cannabis businesses. As I said during those hearings last session, this is a young industry and its regulator is even younger and will continue to grow and evolve, and we will likely come back here every couple years to make any necessary changes that we need to in statute. And that brings us to the bill that I am presenting you here today. In part, it is a cleanup bill, but it also has some other additional clarifying language that I think is necessary when we're talking about a new regulatory agency that's less than 5 years old, and I think it's incumbent on us to keep coming back and correcting this when we see that there are issues with the laws that we passed. Administrative holds are when, what this talks about, I'll start off with probably the easiest thing, and then I will talk about the more complex thing that I'm seeking to change in Senate Bill 168, is one, it's increasing packaging sizes. This is just something consistent with what we passed in 2023. We just want to make sure that there's uniformity in these increased packaging levels that consumers can now purchase within the regulated market. The second thing is the CCB's administrative holds. Administrative holds are when the CCB freezes products in a seed-to-sale tracking system. So if anyone has had the opportunity to tour any one of our cannabis businesses, you probably have seen this, especially if you've gone to a place that not only cultivates but manufactures and has a storefront, so you can kind of see all levels of it. And if you haven't done one of these tours, I would encourage everyone to do so. I think it's a fascinating process to see, and you can see just how regulated and how safe this market is for consumers in our state. When the CCB, though, issues a hold on products, they can't be sold or transferred. It's almost the equivalent. In some cases, they actually put up tape on the thing, like caution tape, that's like, do not sell, do not move, do not touch these products. And the products must be taken down from shelves, removed from customers' online orders, pulled off of trucks delivering to stores across the state. And depending on the scope of the hold, this could be anywhere from tens of thousands to millions of dollars worth of products. The hold itself doesn't freeze the product from being sold at the store, so it usually becomes a huge scramble to pull the products off the floor and online to make sure they don't accidentally get sold or create another compliance violation. As you can imagine, this is particularly can be particularly frantic if you have a problem with a plant and that plant has later been cultivated into and put into many different products. So you have to figure out where that product was. Was it drinks? Was it gummies? Was it, pre-rolls? Where was that product located? And so trying to scramble to get a hold of those are that. Again, I want to say that administrative holds are not recalls. So when you think of you go to Costco and they do a recall on your chicken nuggets and you get an email saying, we know you bought chicken nuggets. There's been a recall. Don't eat them, return them. We'll give you a refund. Those are recalls. This is just an administrative hold. They're essentially putting on a pause while the CCB investigates whether or not an issue exists. This is where we see problems within this industry, and this is why this bill is here today. In most regulated holds or recalls, there's like more administrative due process. I know that you've heard about due process in this committee a lot, and this is bringing a little bit of that due process to the CCB and these administrative hold process. Sometimes the pause can last for months. It can last for up to a half a year in some cases. And during that time, the products are just sitting in a backroom storage. They can't get rid of them. They can't use them. They can't utilize them. And oftentimes they expire before any kind of resolution has been determined on whether or not the product is in fact safe or needs to be recalled, or what the ultimate resolution of the investigation is. There's been many cases where the CCB completes the investigation, releases the hold, but again, the products are expired during that period. So the product turns out to be fine with no safety issues, and it's okay to sell, but because it took so long, they cannot be sold, and this is costing millions and millions of dollars to our cannabis industry. What I've tried to do in Senate Bill 168 is have that balance for the CCB to make sure that the items that are placed on administrative hold, but add back some of those checks and balances to make sure that those holds are not indefinite. It also requires the CCB to provide more information about the reason for the hold in that area. I can go through the individual details of the bill, but there is one thing that I would like to point out to this committee. If you go to Section 5 of the bill, Section 6 of the bill, subsection 2B, this actually should not have been in this bill, and it was not caught during drafting. On April 9th, Commerce and Labor in the Senate, when they amended and do pass this bill, it was to remove that section. Unfortunately, when the amendment was later adopted on the Senate floor, we just did not catch it, and we voted on it, and it came over here. So it was always our intention to make sure that Section 6, Section 2, subsection B would be eliminated. If you look at the work session document, actually from the Senate Commerce and Labor on that second date on April 9th, you will see that that was our intention. It was, we just didn't catch it, unfortunately. So I appreciate this committee recognizing that, and that was some of the confusion and delay that we had to deal with this morning. So I appreciate your patience with that. So if you have any other questions about the bill, we are ready for answers. I believe Lake Martin with the Nevada Cannabis Association is present in Las Vegas to answer any other technical questions you might have for the industry and how this might affect their members.
Thank you so much. Just one moment, please, before we begin questions. All right, thank you. Our first question will be from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for joining us this morning. So my question is actually just above that on Section 6, Sub 2A, where it talks about how the board should issue a hold only under circumstances in which, and then there's a whole bunch there, but at the bottom it says constitutes a substantial hazard to public health. So my question is, are they issuing holds now that have nothing to do with health and safety? Is that to kind of tighten that up, or is that standard practice?
Right now, there isn't a lot of guidance in this area. What this section would do is, one of the bills that we passed during the last legislative session was the Cannabis Compliance Board used to adopt and create their own regulations, and it was they were self-regulatory. What we did during the last legislative session is we passed a bill, I think it was Senate Bill 321 in the 23 legislative session, that actually brought the CCB back under the Administrative Procedures Act. So now when they develop regulations or rules and they're doing their rulemaking, they actually have to come to the Legislative Commission, make sure that what they're attempting to do is in alignment with what we are what our legislative intent was, so they have to get that approval from the Legislative Commission before they adopt any of those regulations. So definitional terms like substantial hazard to public health would be done through that regulatory process, and it would ultimately come to the Legislative Commission for adoption of those rules and those definitions.
Sure.
No, and I appreciate that process for sure. I'm just asking currently, we don't really know whether the holds are related to public health or not, or are they? I'm just trying to get a sense of if this is a change or is this continuing standard practice?
I know that the executive director is from the Cannabis Compliance Board, can probably answer those questions. I believe that he will be coming up in neutral, so he can give you some more specifics. I know in talking with some of the constituents, and this was brought to me by a neighbor that lives down the street, Bonnie Chu. I always got to give her a shout out because she was the first cannabis business that I toured. And during that time, I know that I've heard many stories through my outreach to the business community in this area, that sometimes there was an example where there was an administrative hold on a product, and it was purported to be for safety, and ultimately all the products were pulled. And it turned out it wasn't an overdosing of cannabis, it was actually an underdosing of cannabis. So I would argue in that situation, that was a situation where there was an administrative hold that really wasn't about safety. Obviously, there was a problem there, and probably more of a consumer protection issue, that people were not getting as many milligrams of THC than they thought they were. So that is one example that I'm at least aware of.
Thank you. So I'll wait, members may be on the same page. Assemblymember Ordlicker.
Thank you, Chair. Thank you for bringing this bill. I also have a question about the substantial hazard. So you've indicated that this will be sorted out through the board, subject to approval by the Legislative Commission. But I'm curious about whether substantial risk to public health or hazard is something that we have elsewhere. It sounds like maybe a higher threshold than we would want. Given public health threats, significant might be enough rather than substantial. What's the thinking behind that choice of terms?
Rochelle Wynn for the record. I think our feeling was trying to maintain that balance right now, where there isn't a whole lot of determination on those administrative holds, and the intent, my understanding of the intent of having those holds was because they were based on health concerns or recall concerns or some of the things that you would have in other regulated industries. And I think this maintains kind of that balance that we're hoping to make sure that consumers are protected, but also the industry has those protections and that due process in place. Again, I think this is a good opportunity for us to decide whether or not substantial hazard to public health means by determining whether or not that should be more aggressive or less aggressive or somewhere in between. So I'm really glad that both of you are actually asking that question, because when the Legislative Commission receives some definitional questions, they'll be able to go back to this and say, this is what we think the legislature intended, and that this definition perhaps goes further than we anticipated. And I think there's also, because it now goes through the Legislative Commission, that gives us another opportunity for people to have their voice heard on whether or not the definition is too broad or too narrow.
Yeah, so I imagine this question comes up in other areas, and I see we have somebody from the Department of Agriculture. For food and other products, consumer products, do we say it has to be a substantial hazard before it's subject to limitation? That seems, as I say, I would be nervous if that was all the protection I get is from substantial hazards.
Rochelle Wynn for the record. With the chair's permission, we can ask the Director Gokachia to come up here and perhaps answer those questions for the assembly member if you'd like.
Yes, please.
Good morning, Madam Chair, members of the committee. Director Goycochea, Goicoechea, from the Nevada Department of Agriculture. Assembly Chair, through you to the Assembly member.
Please go direct.
Yes, ma'am. That is a really good question, and that is why you do see me sitting in here this morning to a large part. We did have some concern with some language that was still in there. The bill sponsor did explain to you that that was supposed to have been removed, and that was, again, dealing with some of that, what's the exact terminology here? I apologize again. Unsafe levels, significant public health. We do not do that in other food sources. So if it is public health, we consider it significant. That word, it was of concern to us. And this is mostly based upon pesticide use. And so we were concerned that this may be allowing a loophole where some non-labeled pesticides would be able to be used on cannabis, and then we would not be able to test for the inert ingredients in there. And those can, in fact, cause a problem. If they are labeled for non-food use, there's a reason they're labeled for non-food use. And it's most likely because those inert ingredients can cause a problem to public health. So we adhere strictly to FDA and USDA guidelines when we are inspecting your food. As the sponsor said, this is a new and emerging industry in Nevada, and so we're all trying to get this together, and we would definitely like to have that same application apply here, but they do not regulate cannabis at the federal level. So we are trying to do the best we can as a state agency in pulling those guidelines over and yet still making this industry be able to move forward.
Thank you so much for that. Thank you. I think my question comes more about the process. So of course, we're already making, aligning with what we see with the health department, right? And so I think the best example we all have is health department comes into a restaurant, things are out of order, health department can immediately shut the restaurant down, right? But when it comes to a restaurant, they also come back immediately to check on things. And, often that restaurant, they've met the criteria. And those of us who have ever worked in food service know it can be very particular. A melted spatula can get you some demerits, right? So they come back often the next day, they see that things are in proper order and okay, now everything's open, everything's fine, and we've changed the grade again. What is the process though when it comes to cannabis? Because it seems like we pull stuff off the shelf, there's this thing about 30 days, but again, as we're looking through the lens of business and consumer, what's the process then? Is there an expectation of when I can expect them to come back and, oh, look, everything's fine, or at least define what that administrative, because again, we're kind of like, is this administrative or health? What's the process?
Rochelle Wynn for the record. That's part of the problem. There isn't a process. Right now, one of these investigatory agents can come in and shut down and put an administrative hold without going to the CCB board first. So without doing that. And so that's why there is such a timeline. I do see Lake Martin there, and I think she would probably be best, and I'm putting her on the spot right now because I know
she sat in the chair, so I don't think she's on the
I
spot.
feel like too, but I think she would be able to illustrate this best because she has so many examples of her members that have gone through that. So if I could turn it over to you, Ms. Martin, to go ahead and maybe give an example of how this process currently works and why there's a need for this process and how we came up with that 30-day time period.
Thank you. Good morning. Lake Martin, LAYKEMARTIN, Nevada Cannabis Association. Chair, to your question, I can give the operator's perspective. So everything in Nevada is tracked seed to sale, and it's tracked through a system called Metric, which is software. And so an administrative hold, when it's issued, it is issued notifying you that all of the products across that network are frozen. And so then on the operator side, then they go into their stores, pull it from the shelves, pull it out of customers' baskets online, pull it off trucks if it's being shipped. The administrative hold process is different than a recall process. Administrative holds are placed frequently where the CCB is intending to investigate whether it's an ingredient that's been used in a brand, in a type of product, or in the case that Senator Wynn mentioned, the potency that was coming out from a lab was being reported higher than actual. So that's an administrative hold. It's not an immediate public safety issue. Like Senator Wynn said, it may not be as potent as you were expecting, but that's a case where an administrative hold be used. And so the problem right now is that in many cases, that hold is placed and there's no definite timeline for when it will be released. And we have products with expiration dates. And so often the administrative hold is placed indefinitely and the product expires, and then the administrative hold is released and the product is expired. And so we're looking at like tens of thousands of more dollars worth of product that can't be sold once the hold is released. And so that's really what this is trying to address, so that if there is an issue, it is brought before the board within 30 days and the hold can be extended. If there's not an issue, that really it creates a timeline and more communication between the CCB and the manufacturer for when that hold will be released, like what needs to be done in order for that hold to be released.
Thank you for that, Ms. Martin. And as you're talking about product expiring, obviously this is a loss to our businesses. Do you have examples of, just to give us a better idea, maybe either any business, how much of a financial loss they've had in one of these instances, or maybe the longest administrative hold you've seen, and also maybe how often this happens?
Thank you, Chair. Lake Martin, Nevada Cannabis Association. We have seen holds, I think there are still some holds dating back to last summer, but we have seen holds that extend for many months. And we have licensees that have lost $100,000 worth of product. And certainly that's not all holds and not all cases, but that has happened.
Right, more of the extreme ones. Okay, thank you.
Yes.
I appreciate that. We'll go to Assemblymember Nadeem for a question.
Thank you so much, Chair. That was exactly what I wanted to ask, what the Chair just asked. But do you have any example, any specific example that it happened and then the product went to waste?
Thank you very much. Lake Martin, Nevada Cannabis Association. Yes, we had a licensee with the production license that had a hold placed, and that hold lasted for 6 months or so, and all of their particular products that used an ingredient that the CCB was investigating and went to waste when the hold was released.
Rochelle Wynn for the record. I think it's also particularly, again, to distinguish between administrative holds and recalls. This is just a part of the initial investigatory process. And as the chair rightfully said, if you have a restaurant and you have an inspection and there's a procedure for how you can reopen your restaurant. There's a procedure and there's a timeline for how you can make corrective actions. And this attempts to insert that same type of due process for these businesses that doesn't currently exist.
So let me ask a very rabbit hole question. I heard it was mentioned that with this, if I heard correctly, that the administrative hold could be placed without going to the cannabis board currently, right now?
Rochelle Wynn for the record. That's correct.
Can you speak to possible conflicts or challenges that brings without at least informing the cannabis board first? Because it seems to, I would perceive that the average person in Nevada probably believes that that's the role of the cannabis board. Because, just thinking about that's what the health department does, and that's what this department does. So can you speak to the challenge of that disconnect?
Rochelle Wynn for the record. I do believe it's because this is a new agency. I mean, it's a new regulatory board. There are members, including myself, that were voted on like creating the CCB. So, including yourself, Chair. So I know you're familiar with this. And I think that's where we run into some of the issues. You can see in the language of this bill, like an agent or an agent of the board can still issue that hold notice. If you see that in section 6, subsection 2, that language still allows for it. We had initially had like an even shorter timeline of 14 days for that issue to be hold or addressed or extended or whatever that's contained in section D, which will now be C of this bill. And those are kind of the conversations that we've had. And we've been very fortunate with the current executive director, or the director of the CCB right now. I know that with industry, there's a lot more communication that's taking place more now than ever before with some of these regulatory changes that we made during the last legislative session. And so this gives them an adequate number of time to get the board together to have those kind of conversations on whether or not this hold is appropriate, whether it needs to go on. And it gives some certainty in a business, like any business wants certainty in their rules and regulations. And so the cannabis industry is no different. But I really do think that a lot of that disconnect has to do with like this industry being in its infancy, and also dealing with some of the other challenges that you have around a regulated industry in the state of Nevada that isn't regulated in the state and, federally. You saw that we're trying to bring in some of the, things that we see in the Department of Agriculture, and we are bringing them over here because that's the closest thing that we have right now. Like, I think when we started the CCB, we kind of looked to the gaming industry, and we've kind of stepped back from that, and we've come back and refined that because gaming is not like the CCB. And so I think that is really where some of that disconnect, and this helps to bridge some of that and bring some more clarity to this industry.
Thank you so much. With that, I don't see any additional questions, so I will go ahead and open it up for testimony. Beginning here in Carson City, anyone that would like to testify in support of Senate Bill 168.
Good morning, Chair Miller, members of the committee, Brett Scolari, Strategies 360, BRETTSCOLARI, here on behalf of Cura Cannabis Solutions and Thrive Cannabis Marketplace. Wanted to just quickly give a big thank you to Senator Wynn for working on this issue. I think it sets a really good framework for us to work with the CCB and the Department of Ag on these regulations to set up a process for these administrative holds. There are, as been discussed, there are situations where the industry believes that those holds can be lifted and the product can be saved. So this will set up that process and the backstop to go to the board if by chance you aren't agreeing with staff, CCB staff, you have that check and balance with the board to plead your case there. So I think it's a really good way to set this up, and we look forward to working on the regulations with the agencies. Thank you.
Will Adler, for the record, with Silver State Government Relations, representing Green Thumbs Industries, or GTI. I just wanted to speak to a couple of the things heard in the Q&A. A lot of this comes from the cannabis industry.
Okay, so Mr. Adler, are you testifying in support?
Yes, in
Okay.
support and just explanation of the need for this bill. So a lot of this comes from the newness of the cannabis industry and the lack of federal regulations previously there. We did empower the CCB to have these additional regular oversights, similar to the Department of Ag or Department of Health. They just had to have the empowerment to do this because those other agencies cannot. They're empowered under federal regulations around what is proper pesticide use, what is proper food safety. This is the gray area where the CCB had to fill in the gap, but the grayness was sort of in the implementation of these powers. So as was spoken to, holds are sort of implemented around administrative needs, not safety needs. Safety needs are around the testing industry. The testing of cannabis is done independently of holds or sort of the whole process. If you have a failed test or a wrong pesticide use, you'll actually get a recall of the product, a mandatory revoking, and that product's off the shelf forever. A hold administratively is the secondary judgment of, is it correctly labeled? Are we in the right spot? Is it used in this way or that? But to be very clear that, there is a secondary function similar to Department of Agriculture, CCB functionally does, where they inspect cultivations and they actually determine, are they using the right pesticides, fertilizers, and is there anything on their shelves they shouldn't have? So it's sort of a non-use inspection to make sure products that are not, useful for cannabis or would be harmful aren't in the building. A test to prove that it passes the test, and then this administrative function is more around, is it labeled correctly? Is it there? But to be clear, GTI had a hold in February 2022, or February 2020, where we actually had over $200,000 worth of product held administratively just because essentially the labels were not correct based on that inspection. It was held for over 9 months to the point where we actually asked for a proper notice to destroy the product because it was held in place and using up over a quarter of the shelf space in the store. So we actually just asked to destroy the product ourselves just so we could use the functional shelf space in the store. But yes, we've seen large holds happen in the past and large losses of product because of it. So I want to thank Senator Wynn for bringing this bill forward, and thank you for allowing me to explain the niche here. Thank you.
Thank you. Is there anyone else here in Carson City that would like to testify in support? Okay, we'll move to Las Vegas, please.
Hi, everyone. For the record, my name is Alyssa Naveworth, ALISA-NAVE-WORTH, on behalf of Cornerstone Government Affairs, today representing Planet 13. We want to thank Senator Wynn for her leadership on this issue. It's an important issue for the industry, and we echo the sentiments of those that spoke before us.
Thank you.
Good morning again, Chair Lake Martin, Nevada Cannabis Association, the trade association for Nevada's licensed cannabis businesses. Again, we are in support and thank Senator Wynn for bringing this bill.
Good morning, Chair Miller, Vice Chair Marzola, Mackenzie Warren Kay with Brownstein on behalf of Deep Roots Harvest, WARRENKAY. Also here in support on Senate Bill 168, Senator Wynn has been a tremendous ally to the industry. Deep Roots is in particular support of a couple sections that didn't get as much airtime today, but we want to point them out. Sections 10 and 14, so those relate to packaging and labeling. These amendments may sound familiar to the committee. The purpose here is to remove any duplicative requirements without sacrificing that key information that's critical for the consumer to have the consumer awareness and also understand any safety implications. To be clear, a cannabis operator will only be able to opt out of any labeling requirements if that required information is also contained on the package. I also want to acknowledge the CCB for working with us to get the language right. And again, thank the sponsor and urge your support. Thank you.
Thank you. Is there anyone else there in Las Vegas wishing to come forward? Not seeing anyone. Broadcasting, will you please open the lines?
Public line is open and working. There are no callers at this time.
Thank you. Then I'll open it up for opposition testimony, beginning here in Carson City. Not seeing any. Is there anyone there in Las Vegas that would like to testify in opposition? Also not seeing anyone. Broadcasting, please open the lines.
The public line is open and working. There are no callers at this time.
Thank you. Then I'll open it up for neutral testimony. Anyone here in Carson City that would like to testify in neutral?
Thank you, Chair, members of the committee. James Hum, Cannabis Compliance, Executive Director, Cannabis Compliance Board, JAMESHUMM. Just wanted to come up, testify in neutral, thank the bill sponsor for working with us so diligently on this and really fine-tuning the language. We are committed to promulgating these regulations in the interim and look forward to continue to work with industry as we move forward.
Madam Chair, members of the committee, again, Director Goycochea, GOI, COE, CHEA, Nevada Department of Agriculture. We also come forward in neutral at this time and thank the sponsor for the meeting in the hallway. Thank the chair for allowing that to occur this morning and moving us to a better place. I just want the committee to realize that part of this is the inert ingredients that are a trade secret, and so we do not know what they are in many of our pesticide products. Therefore, if a product is used illegally or inadvertently, there is literally no way we can test for those inert ingredients. The EPA currently lists nearly 5,000 inert ingredients, and we just do not have that mechanism. So we thank the sponsor for realizing that, and we stand ready to work with the CCB and members of the cannabis industry to get these regulations correct and move this industry forward. Thank you.
Thank you. We will move to Las Vegas for neutral testimony.
Good morning, Kara Cronkite, Cronkhite. I am the Chief of Health and Safety for the Cannabis Compliance Board. I just wanted to thank the committee for their willingness to work with us on this bill and just answer a few of the questions that were asked earlier or provide clarifications. We do only place holds for a potential risk to public health and safety. As Director Goycochea said, we cannot test for everything, so holds are very important procedure for us. Mislabeling the potency is still a risk to public health. If they are underdosing, the consumer may think that their tolerance is higher than it is and then overconsume the next time. They also may be misdosing their medications. Holds are only lifted after expirations so that the facility can destroy them. That is the only time that has occurred. And then typical language for public health and safety is potential risk to public health rather than a substantial risk to public health. So I would recommend that language. I did used to work for the Southern Nevada Health District, and I've worked in public health for nearly 20 years. We do follow the same processes. If food is held at a temperature, for example, it must be discarded right there, and the inspector is the one that makes that determination. We do have a policy in place for holds. They're approved by myself, the Chief of Health and Safety, and also the executive team, including both of the executive director and the deputy director, as well as our legal team. The risk is already determined to exist. Holds only typically last while we work with the licensee on next steps, if there are any. Sometimes relabeling will answer all of, be a solution to all of the issues, but usually it ends in destruction. So something that may sound just like a simple labeling issue is typically something like not listing peanuts as an allergen in a chocolate bar, for example. That is something that we did run into before. We do allow them to correct the labels.
Thank you so much.
Thank you.
Thank you. Not seeing anyone else there in Las Vegas Broadcasting. Will you open the lines, please?
The public line is open and working. There are no callers at this time.
Thank you. Then I'll welcome the senator back up for any final words.
Rochelle Wynn, briefly in closing. Obviously, a little inconsistent messaging on some of that language that's included in the bill between the executive director of the CCB and the person that just testified in neutral. So I will continue to have those conversations, and it sounds like it's in alignment with some of the questions that Assemblymember Ohrenlicker asked, so I might reach out to you if that's okay, to see if we can come up with some additional things, but I appreciate your time and your consideration of this bill.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 168. Next on our agenda is public comment. So again, just reminding anyone who would like to make public comment that it is not to refer to any of the bills that we heard today, but to other aspects that are under the purview of this committee. And so I'll open up public comment to first here in Carson City. Not seeing anyone. Is there anyone in Las Vegas who would like to make public comment? Also not seeing anyone. Broadcasting, will you open the lines, please?
Chair, the public line is open and working, and there are no callers at this time.
Thank you. Then I will go ahead and close public comment, and we have concluded our work for today. So I will adjourn and see you all back at 8 a.m. tomorrow morning.